My guest this hour, criminal defense and civil attorney Gerald Griggs. He's also the attorney for several of the R. Kelly accusers. I want to thank you very much, Gerald, for being with me this evening.
Thank you for having me.
All right, so we got some pretty interesting issues here regarding self-defense. We're finding out a little bit about what they're going to claim. They're going to claim that initial approach was really a citizen's arrest, and then what happened after amounted to self-defense. Now, we know that self-defense allows a defendant to bring in evidence regarding reputation and opinion of the victim, and they presented some of that evidence, but the state rightly made the claim that they knew nothing of that reputation. They knew nothing of all these other issues that Ahmaud Arbery had had, so there was no reason to bring that in front of a jury. Love to get your thoughts on that.
Yes, and I think the state is correct. I mean, if we're testing the reasonableness of their actions, we have to go by what they knew. And at the time, they knew none of this. So I think she's correct in arguing that it's irrelevant under 441 and 442. It has to have evidence that tends to prove or disprove a fact at issue. The facts are at issue is whether or not they were lawful in the detention of Mr. Arbery and then ultimately shooting him. Not about his prior information or behavior in 2013 or 2015 or 2017. So I think that's the problem that the defense is going to have in introducing this evidence and allowing a judge to let it into the jury. But even if he does let it in, it has to go through 403, which is grounds to exclude it because it's too prejudicial, confusing, or a waste of time. What element of self-defense does this prove if the defendant did not know about the information before their actions?
Now, what they were arguing here, Gerald, is that under 404B, you can bring it in to prove motive or intent of the victim in this case. So what they're claiming is that, and you saw a little bit of a confrontation he had with a police officer. They showed a couple of others where he tended to respond in an aggressive manner to authority figures. And so they wanted to say, well, this shows part of his intent in his response, which caused this situation that was going to require the self-defense of the defendants, saying it goes to his thought process, and they think that's why it's relevant. Any thoughts on that?
And my thoughts on it, it's a careful and clever defense, but the intent or the state of mind of the victim is not an issue here. So I think that they're going to have a real issue proving that up. And even if they do, they got to get past the 403 argument, which is the true gatekeeper of whether relevant evidence gets in on the grounds of prejudice, confusion, or a waste of time. And even if it does get in, it cannot show conformity, and that's what they're trying to show. That conduct was in conformity. It does not go to motive. It goes to he acted this way once, he acted this way in this situation, and that's the crux of why evidence of conduct or character is not admissible in Georgia.
Yeah, and absolutely. And you mentioned it, that 403 thing is whether the evidence is more prejudicial than it is probative. And at the end of the day, that's sort of that, like you said, the gatekeeper that the judge will consider. And I don't think it's going to pass muster under that consideration. All right, Gerald, stand by. We do have to take a break right now. Some of the testimony in today's hearing began to unravel a bit under some tough cross-examination by the state's attorney. We'll dig deeper on testimony about Ahmaud Arbery's past just ahead. So keep it right where it is on Court TV. Welcome back to Court TV Live. I'm Michael Ayala. As part of the defense's motions to introduce evidence, including prior bad acts by Ahmaud Arbery, so far they called multiple witnesses today, including someone named Crystal Wilson. Now, she is the focus of today's close-up. Wilson testified that as an assistant manager of Love's Truck Stop, she witnessed Ahmaud Arbery shoplift multiple times. Take a listen.
How is it that you have come to meet Mr. Arbery?
He was a regular shoplifter in our store.
Okay. When you say he was a regular shoplifter, how often would you say that he shoplifted?
Not really sure. After the first few times I watched him, so I know there were about 8 instances that we've caught him.
Okay. Can you tell me when you began to observe this behavior by Mr. Arbery?
Probably within the last year or two before.
Before his death?
Yes.
Okay, so would that include 2018
I believe so, yes.
and 2019. Would it also include 2020 leading up to around February 23rd?
Yes.
Okay. And when you say that you saw him about 8 instances, what do you mean by 8 instances?
That he actually physically took merchandise.
Okay. Can you describe what you would see when he would do that?
As far as inside the store?
Yes, ma'am.
He pretty much just came in, grabbed food, and then usually at that point I noticed him and he would run out the door.
Now, although she didn't know Arbery's name until after his death, Wilson said that she recognized him from the incidents. And although she testified he had stolen items multiple times, she actually called the police only once.
The last time was right around the beginning of February.
Of what year?
20.
Of 2020.
A few weeks, yes.
Okay. Were you there on that instance?
Yes.
And what happened on that day?
I was actually outside doing a perimeter walk. He had come in the front door, and our first aisle right there was Frito-Lay. He grabbed a bunch of chips and then ran out the door. My cashier called me on the radio and told me what happened. And at that same instance, he had come around the side of the building I was on. I yelled at him to stop. One of my employees happened to be pulling up and saw what was going on and just immediately had started chasing him. And that's the instance that I did call the police because I was worried for both of them.
Why were you worried?
I obviously did not want my cashier getting hurt or Mr. Arbery getting hurt. I didn't know if it was going to lead to an altercation. So I did call the cops to try to prevent anything from occurring.
Did it lead to an altercation?
No.
Now, in questioning by the state, her testimony started to become a bit questionable when she said that not only was there no video evidence of Arbery committing any of these offenses, but in fact, she could barely describe him at all.
So let's go ahead and talk about incident number 1. Can you describe him, the person who came in and shoplifted?
As far as what happened, or as far as what he looked like, or just
What did he look like?
just a young black male.
Anything that would distinguish him from any other young black male on the planet?
No.
Number 2, same thing?
Same thing.
Number 3, same thing.
Well, now, obviously, after the first couple times of noticing that he stole, we would keep an eye on him when he came in, yes.
All right. So you now were able to
Took a
recognize him.
couple times, yes, ma'am.
I want to bring back criminal defense and civil attorney Gerald Griggs. And Gerald, you know, under the guise of zealous representation, defense attorneys do a lot of different things. And I got to thinking, I said this particular evidence, for instance, it really was going to show propensity in the fact that perhaps when he went into that vacant home, maybe he was looking to steal something, had a propensity to steal. We know clearly the law says that can't happen. So I said, why would a defense attorney want to bring these in? Then I started to think, part of what they might be doing here, and I want to get your opinion on this, is wanting to get these incidents out in front of the public eye any way they can to sort of curry favor and put it in the minds of a potential jury pool that, in fact, some of these issues existed with Arbery, which could eventually help their case.
Yeah, I think that's exactly what's happening here, because we all know that this would not come in under the character evidence rule. It's clearly propensity. It's clearly irrelevant and has nothing to do with anything that happened in this particular case. But with a high profile case like this one, you want to try to get as much information out as possible. This case has been seen around the world. So I think that was a strategy. I think the judge is probably going to exclude this particular witness. She really clearly does not even remember who the alleged victim was. So, I mean, there's some real issues with this evidence, especially the character evidence with regard to propensity.
Yeah, there really was no strong identification. She was clear about that. She never actually went to a police station and identified him or in a lineup or anything like that. So I agree with you. I don't think her testimony would see the light of day in a trial. But here's a question I have for you. They have sort of made clear that their defense is going to be first, of course, there was the citizen's arrest, and then a self-defense claim. And I want to get a sense from you. There were a lot of people who looked at this video, the one that's become famous, the one that went viral, and didn't see a problem with what happened there, that perhaps there was a self-defense claim. Is there any way For our viewers out there who are watching and wondering that a self-defense claim could be supported here by what you see on that video?
Absolutely not. I mean, in Georgia, you cannot be the primary aggressor and then claim self-defense. I think that's what ADA Dunikowski was arguing to the court. I mean, it's clear in the jury charges, you cannot be the primary aggressor and claim self-defense. That's why I thought they were going with the citizen's arrest statute. But again, from what I heard today, it seems as they're going with a detention as opposed to an arrest, which is a very big distinction under the law. If they're going with a detention, then I do think she's correct. It's a false imprisonment. And then if it's a false imprisonment, you are the primary aggressor, and thus you're not entitled to self-defense. So it's kind of interesting to listen to the arguments that are being made. But once the evidence comes out, I will be able to definitely determine the status of the law in Georgia. But if they're going with the argument that their counsel made, they may be making a tactical mistake.
You make a great point, Gerald, because I was wondering that myself. Going into this, clearly we had thought it was the citizen's arrest, and I thought that was going to be used by the defense to explain that initial confrontation, the one where, clearly they're the aggressor, but they're claiming they had the right because of citizen's arrest. But it sounded like they shifted away from that and was going towards this detention argument, which I think is a weaker argument. What do you think about that as a defense attorney, sort of making that shift? Because the other problem is, of course, I don't know if they can sustain a citizen's arrest according to the law and the knowledge they had at the time.
Yeah, I think citizen's arrest is still going to be a problem. I think that the detention argument is a real bad problem if they go down that route. But even if they go with self-defense, you still can have imperfect self-defense. That's where you go to a fight, you're not the initial aggressor, but then you escalate it past the use of reasonable force to defend yourself. Mr. Arbery was unarmed, so there was no need to use a shotgun to assault him. So in Georgia, you can use self-defense, but it cannot be imperfect self-defense. So there are several major issues with this case. And again, if they shift away from the citizen's arrest statute, which again is questionable at best, which is why it was overturned. But now you're going down that road. It's a very dangerous road to trod as a defense attorney. And of course, in order to claim self-defense, you have to have some evidence, which means that maybe your client has to testify and answer some very tough questions. So I'm concerned and curious to watch how this case plays out.
Yes, so many issues still to be decided here. Gerald Griggs, thank you so much for joining me this evening. Our time was short, but hopefully you'll come back and join us again. Really enjoyed your insights on this case.
Thank you for having me.
All right, now.